let's let's talk about the this harassment case. Whatever, were you ever charged with harassment?
They charged me, but the case was dismissed for lack of evidence.
Okay. Have there been any other charges against you over allegations of things you might have done to Miss Whetstone?
No, never. And I never, we don't talk on the phone. I've lived 10 hours away from her for the last 9 years. I don't talk to her. She refuses to let me get my kids, so I never see my kids.
All right, this time, court's going to go on the record and call Bell County calls number 269,313. Non-custodial party in this matter is Mr. Robert Thomas Baker. Custodial party is Michelle Antoinette Whetstone. And this matter is before the court on a motion to confirm arrears and child support modification. The court reset this matter to give Mr. Mr. Baker the opportunity to confirm direct payments via copies of checks from Chase Manhattan, is my understanding. He had that were more than 7 years old, so he had to go to them directly to get those older checks. But anyway, we reset this matter for today's date to allow him to do that, and the court did request that if he could to get a copy of those checks and put them into a spreadsheet form so we could take a look at them and not have to go over them individually or just confirm them individually as being in the spreadsheet. But our understanding is that none of that has been forwarded to the state. So let me get everybody on the record and find out what's going on here, where we can confirm one way or the other. What are we looking at this point? And I also was looking at the retroactive cash medical, and I can get some more information on that and get some confirmation on what they may be looking at as far as that's concerned. But anyway, at this time, we're on the record, and I'll ask the state for an opening to tell the court what the state's requesting we do here today, what the state understands the circumstances are, and we'll take it from there. At the end of the hearing, either party can make a closing statement in their own behalf as their own legal rep. But again, I always let the lawyers make the opening because it's only to figure out what the issues are that are going before the court this time. So at this time, Mr. Diamond, you're up. Thank you.
Thank you, Your Honor. So, Your Honor, my understanding, we do have a partial agreement, which is the child support going forward to be $433. Medical support.
I remember that from the original hearing. Yeah, got that.
And the medical support is zero, dental support zero. Miss Whetstone has, well, her husband has TRICARE, so that's, I'd probably put it as in the order as another source, but that would be the source. Those are the agreement, and I would ask the court to order those to start September 1, unless the evidence.
Well, we're looking at on the cash medical, since mom hasn't been paying cash medical, starting that on the date of service. But I'll confirm that. I'll have you confirm that with testimony. All right.
Yes, Your Honor. The other issues. So my understanding is Mr. Baker is going to tell the court about his attempts to get his documentation, but I understand there's not any to be presented to the court. So going to be requesting the court to confirm the child support. I'm not. I want to wait to see what the court does before I spit out a date and a number, but that's the child support. Then the medical support, Mr. Baker has raised an equitable issue. Ms. Whetstone is not in agreement, and his position is that when she remarried, the children went on her husband's TRICARE. So if the court is going to consider that, I believe the testimony will be that Ms. Whetstone was remarried in March of 2019. I would urge, if the court's going to consider this May of 2019 being the date to start, because there was probably some enrollment time, and that's probably being conservative. But Mr. Baker is requesting credits against what he would owe, and so if we're going to confirm the arrears as of August 31, and if we're not, then I'd have to revise these numbers. But if we're confirming the arrears as of August 31, 9,600 would be the principal credit he's requesting. I've calculated the interest at $1,464.75. So the principal plus interest, $11,064.75. Again, that's if we confirm as of August 31. Mr. Baker is requesting it's not really credits because he didn't pay anything, but he's asking the medical support arrears to be to the 11,064 and 75 cents to be subtracted from the medical support arrears on the grounds that even though he wasn't paying her, there was no cost to her. There wasn't anything to reimburse. I believe his argument. I believe Ms. Whetstone's retort is going to be that on a number of occasions she requested cash medical reimbursement. Mr. Baker refused to reimburse her. And I think that her testimony to the court is going to be that the cash medical reimbursement that maybe she should have sought, and that maybe my agency wasn't as helpful as we could have been in assisting her in seeking that, although we are constrained with our resources, is going to exceed whatever 11,000 something credit that he could have gotten against what he would have been paying. And I realize my statement's not very succinct, but I think the court understands what I'm trying to say.
Oh yeah, I got it.
And then the other thing, Your Honor, I believe the testimony from Ms. Whetstone will be that she's not concerned about Mr. Baker, but I believe there have been incidents between the two of them, and I'd ask the court to hear that evidence and make an appropriate ruling about non-disclosure.
Is there currently a non-disclosure finding in this case?
And I should know the answer to that, Your Honor. So we're still on the divorce decree is still the controlling order, and I don't know that there was.
Yeah, I'm sorry, that's never in a divorce decree. So yeah, so.
But I believe there's been issues since, and so I'd ask the court to hear the evidence and make an appropriate ruling.
And I need that evidence probably to be within the last 2-year time frame. All right. So
yes, Your Honor.
All right, so folks, let's go ahead and get you under oath and let's get some testimony here at this time. So are you there, sir? You can turn your video, ma'am. I see you just unmute yourselves, and I'll ask you both to raise your right hands. Mr. Baker, you're on the landline, so just raise your right hand. Thank you. Do both of you solemnly swear or affirm any testimony you're going to give here today is the truth, the whole truth, and nothing but the truth will help you?
I do.
All right, ma'am, you're still muted. And I still say landline, but I've got technically a landline, but it's technically.
Can you hear me, Your Honor?
Yeah, you're on oath, sir.
Now there you go. Can you hear me?
Yes, ma'am.
Okay, yes, sir.
All right, then you're on oath also. All right, then I'll go ahead and let the state call you both as witnesses, and we'll take it from there. Thank you.
Thank you, Your Honor. Call Ms. Whetstone. Ma'am, will you state your full name, please?
Michelle Whetstone?
And were you able to hear the opening I gave the court just a minute ago, Ms. Whetstone?
Yes, I did.
I know you probably don't agree with everything I told the court, but did I accurately represent to the court the agreements and your position?
Yes, somewhat. I mean, we do pay TRICARE. We do have fees to pay, just like dental and all that stuff. And I do pay out-of-pocket expenses.
Okay. All right. Well, let's go because I was hoping for a resounding yes, but that's if it's not a yes, then it's not a yes. So let's go point by point. So my understanding is that the child support would be $433 going forward. Is that correct?
That's what I heard from last time. I assume. I didn't know if that was final that you guys, because.
Well, that's the number I'm proposing to the court. My understanding is that you can accept that.
Yes, I'll accept it.
Okay, and that's based off of just under $2,600 in gross revenue that I'm looking at. Is that your understanding as well? Did they not tell you the gross when they talk to you?
For me?
Yeah, no, for him.
Oh.
All right. Well, anyway, we've got the number, and then my understanding is your husband will carry the child on insurance through TRICARE. Is that correct?
Yes.
Okay. And my understanding is you're not seeking cash medical reimbursement going forward for Mr. Baker.
From this point on, yes.
Okay, and that's generous to you because there's probably $15-20 a month in dental that you and your husband are paying. Is that correct?
I assume so. My youngest does have braces, so that was like a couple thousand out of pocket. I mean.
Okay, so you're asking for some equitable consideration from the judge, and that you're not trying to hit Baker for the.
Stop. Here's the deal, ma'am. Now and going forward, all uninsured medical expenses are in their own separate little category. Okay, health insurance, dental insurance, and and health and dental insurance are over here with them as far as that payment is concerned. But if there's anything that's out of pocket, you have the right to ask him for a 50% reimbursement, but you've got to send him the request, and you got to send it within a certain amount of time, and then he becomes legally obligated to return and pay it in a certain amount of time. Otherwise, it's just like a violation of non-payment of child support. It can be enforced. And I'm going to put you both on app close because I want, if this because of he said she said stuff going forward. You send him the bill through app close, and he can actually reimburse you through app close, or you do an electronic form that that can be confirmed. But I'm gonna nail this one down going forward, guys. Okay, so thank you.
All right, so let's talk about that some more. So, my understanding, you and your husband you're married March of 2019. Is that correct?
Yes.
All right. So by May of 2019, the TRICARE would have been in effect for your children with Mr. Baker.
You mean my husband? Oh, I guess yes. They would have insurance. Yes.
Baker's child with you was being covered by your new husband.
Yes.
Yeah. All right. So, and my understanding is that you're not in agreement with giving Baker a credit for the medical support that he would have owed but didn't pay.
You don't have to go into that in detail. I don't think there's any way under current Texas law that I could actually give him a credit. It's not voluntary.
Yes, Your Honor.
It was due and owed on the first of each month. It is what it is, and I don't think I can give an equitable credit for that at this time. Only items have actually been paid. This doesn't come up too often, but it has in the past. And once it's due and owed, it's due and owed. So you don't have to go down that path too much. If she doesn't want to give him credit, that's her business. So
yes, Your Honor.
Thank you.
Yes, Your Honor, and thank you for the clarity, Your Honor. All right, so let's talk about. Actually, Your Honor, I'd offer what's been marked as States 1 right now, if I may.
All right, folks, this is States Exhibit number 1, the financial activity report in your case. This shows what has been paid through the state's disbursement unit in accordance with the decree of divorce. So, ma'am, I'll start with you, Ms. Whetstone. Any objection to this coming evidence at this time?
No, sir.
All right. Mr. Baker, is there any legal reason the court shouldn't review this information?
I don't think I understand the question. Are you saying that there's no possible way to give me a equity for?
Okay. You just jumped the shark. Right now, I'm asking you: is there a legal reason why the court should not be able to review what has been paid through the state disbursement union in your case, sir? And then I'll answer your question in a moment. But yeah, okay, it's admitted. There's no legal objection.
So your question is, there's no reason that you can't be reviewed, or what was the?
The thing is, sir, no, sir, I cannot. That money is already due and owed, and the only way for that to be forgiven is by the mother.
Oh, okay. I agree with that. Yes.
Okay, so those are the circumstances. So if nobody came in before that date to change things around legally, then it's still due and owed based on your decree of divorce, sir. So, all right. So,
but in the court decree, it says that if there's any change to that, she has to notify me and the court, and she didn't.
Okay, here's the deal, sir. I can't tell you how to practice law, but you're not doing it. That's not bringing it up right now is probably not going to get you from point A to point B. You would have to file paperwork to get something like that before the court. And then at that point, it would be actually before the court. Right now, the only thing before the court is the state's pleadings, and they don't include anything like that, sir.
Okay.
All right. So at this time, States 1 is admitted. It does show what you paid in child support, cash medical support, and dental support since since your decree of divorce. And the court now can take that into consideration going forward. You may proceed, Mr. Diamond. Thank you.
Thank you, Your Honor. So, Ms. Whetstone, let's talk about. We talked about what's owed. Let's talk about safety now. Do you have safety concerns with Mr. Baker having your address, your telephone number, your email address?
I don't want him to, because I limit contact, because the stuff that he's done. So I don't.
All right, here's the deal. I mean, I'm gonna let the state go into this a moment, but under the law, I'm supposed to look at the last 2 years, and anything that happened before the divorce was granted is inadmissible. All right, it cannot be brought up. All right, so I'll let the state proceed where you get some particulars, Mr. Diamond. Thank you.
Yes, Your Honor. All right. So have there been any issues between you and he in the last 2 years, Ms. Whetstone?
I would say, you know what, he continues to kind of email me. The last stuff I had was 2022, a whole bunch of. But yes, he's done everything since I've been divorced from him. I do have those charges, and like I said, I don't know what happened. I've called 911. I've done all that stuff. I just want to just kind of
Right. But I guess what I'm getting at has he threatened you? Has he harassed you? Has he physically harmed or attempted to harm you in the last 2 years? Is the
not
specific
physically
question.
hard. No, just email. 2022, because I still have all those emails constantly, almost every day, which
Yes,
is,
ma'am.
you know, but I need some type of communication. That's how I communicate with him, is via email and not
Yes,
via
ma'am.
phone.
Okay.
Right.
And
I'm sorry, ma'am. Did he, in any of those emails, did he threaten you with bodily injury or physical harm?
No.
All right, thank you. You may proceed, Mr. Diamond.
do you know if any conviction resulted from, or really any conviction or adjudication resulted from anything he did to you previously between the divorce and today?
So that's what I'm saying. I was like, I don't know what happened. I know the harassment charges because I don't know what came of it. I know the officer was like, yeah, something should have happened, but I never found out what. I just distanced myself. So I can't tell you 100% what happened.
Okay.
Those charges.
But the thing he was charged for happened after the divorce?
Yes, happened after the divorce.
Yes, ma'am.
All right. Again, ma'am, you said you don't know if he was ever charged, and therefore there's and the prosecuting attorney would have been in contact with you, ma'am, and you never have been contacted by a prosecuting attorney in any of these matters.
No, just the officer, the detectives.
And what city was that in?
In Harker Heights.
Okay. All right, then.
So Robert may know. I mean, because
Okay, well, the state's going to ask him whether or not he was ever charged or anything like that. So we'll find out. Thank you. All right. Well, right now, go ahead and proceed then, Mr. Diamond. Thank you.
Thank you, Your Honor. I'll pass the witness.
All right. Be right back to you in a moment, ma'am. Go ahead and call your next witness then, Mr. Diamond. Thank you.
Call Mr. Baker, Your Honor. Sir, will you state your full name, please?
Robert Baker.
All right, so let's go through the agreement first, and then we can get into the other stuff afterwards. So my understanding is that you're in agreement with the current obligations, child support being set at $433 going forward, and the medical support being zero, and medical and dental both being zero. Do I understand correctly?
Yes.
All right, and that's based, my understanding, that's based off of total resources for you, $2,597.90. Does that sound right?
That's what they calculated, but I don't actually have a job haven't worked this year.
Okay.
They just
so
based it off minimum wage, I guess.
No.
I have not worked this year. I had medical issues. They based it. The lady that
Okay.
I talked to on the last court case based it off minimum wage of Illinois, which is twice as much as minimum wage in Texas.
Okay, that's where we're getting from. All right, and then my understanding the state income tax is about $120. Is that correct?
I don't know. I've only been in Illinois a few months.
Okay. Do you receive SSI from the government, from the federal government?
No, I get VA disability.
Okay. And thank you for your service. All right, let's talk about the rest of it. So did I as far as the well, I think a judge has already dealt with it. Let's talk about this harassment case. Whatever, were you ever charged with harassment?
They charged me, but the case was dismissed for lack of evidence.
Okay. Have there been any other charges against you over allegations of things you might have done to Miss Whetstone?
No, never. And we don't talk on the phone. I've lived 10 hours away from her for the last 9 years. I don't talk to her. She refuses to let me get my kids, so I never see my kids. But I haven't talked to her in years. If I want to see the kids, I'll send her an email, but she never responds.
I understand. All right, and my understanding also that you don't have any documentation showing the checks you might have written to Miss Whetstone from Chase Bank. Is that correct?
No, unfortunately, I went to 2 different chases and was on the phone for a long time with corporate, and they cannot go past 7 years back.
Okay. I will pass a witness, Your Honor.
All right, sir. In your original testimony, you were saying that your recollection that those checks were done early in this case.
Yes, when I first was ordered to pay child support, the lawyer I had at the time just said, make sure you pay it with a traceable check. And so I had my bank send out checks.
I'm seeing most of the pay. You were pretty much up to date for the first few years in this matter. And then starting in 2018, 2019, is when all this stuff started happening. There were still payments coming in. But again, sir, if you don't have the proof, then, I can't tell you what your lawyer told you to do and how to set it up, but the bottom line is if it wasn't paid to the state's disbursement unit, sir, I can't give you credit for it. So, all right then. And you say y'all only communicate via email these days, sir?
Yes, but until our son was in a motorcycle wreck last week, we haven't communicated. 6 months ago, I asked her to get Seth for the summer.
I'm sorry. You didn't need. I'm sorry. You didn't need to explain it out. But the bottom line is, I'm going to put y'all onto a parenting app, and all communications going forward is going to be through it, and not email, not Facebook Messenger, nothing like that. We're going to use a parenting app, and I want all communications going forward through that app. It's called App Close, and the state will explain all that to you in a moment. But I'll explain it to you a little bit more in depth in just a moment. Anyway, I'll go ahead and let the state ask the next question. Thank you.
Okay, so no, I think that does it, Your Honor. State rest subject to close.
All right, folks. What I'm looking at is a modification of child support based now on the fact that the father is a resident of Illinois, and they got a different minimum wage than we do. And I hadn't heard any contradictory information that would allow the court to do something different. And I'm thinking they also, sir, are including your VA disability. What's your percentage, sir?
Right now at 10%, but I'm currently working to get it raised.
All right, then. So it's not very much at this point, but obviously, if you get it raised, then you're going to be obligated to let the state know that there's been a raise based on that. But for right now, what I have to look at is the wording of modifying the child support, setting up, modifying the cash medical and the dental, and setting up a repayment plan on the unpaid child support and unpaid medical and cash dental. So that's what the court's looking at. So at this time, I'll go ahead and let the state make a closing statement, closing argument, and then I'll listen to either party. Thank you.
Well, Your Honor, actually the request, maybe some guidance before I go throw a bunch of numbers out. The request would be 433 in the child support, 0 medical, 0 dental. I defer to the court on the start date, but the start date will influence the amount that I would request to confirm in the requested repayment amount.
All right, Mr. Diamond, this is less than $100 up from the old one, and obviously that could be a factor, but I want you to keep that in mind when you make your closing. So go right ahead again. I'm sorry.
Well, I think we're going from $252 to $433, Your Honor.
Okay, I see 278 due when this thing was originally done. That's what I was looking at. Did that change somewhere down the road?
So I'm showing 252 on the child support and 150 on the medical support.
Okay. All right, now I'm looking at your financial activity report, and it's showing the amount due on child support 378. 378, that was that through 2020.
Oh, you know what, Your Honor, I'm sorry. It was probably, I've not reviewed the divorce decree because, well, I give you my reasons. I won't. My guess is that there's probably step down language as to the child support. There was probably not step down language as to the medical support. So the current amount is 252 with just the one child.
Okay.
Uh,
All right. Yeah, I see it now. All right, not a problem. Go ahead.
so again, it's if the court could tell me when the court wants to start the new obligations, assuming that I've carried my burden to get there, then I would request a repayment amount based on that. And then if we could have a ruling on the non-disclosure.
All right. Well, based on the circumstances, I don't think I can grant non-disclosure. There's never been a criminal conviction. He's an innocent man until proven guilty, and there's been nothing in the last 2 years. I am going to go ahead and order the parties into using AppClose. It's free. It's in both Google Play and iTunes. You both can download it. I think, ma'am, you have to set the account up and then get pass the information on and set him up as being able to log in. And I want all communications through AppClose going forward. It's got a texting function. It's got an email function, and it has a FaceTime function. They're all in there. And that way, if something comes up in the future and you can verify that you sent that request through AppClose, ma'am, for the reimbursement, then, sir, you have to, in conformity with your decree of divorce, pay that and pay it on time. Otherwise, mom has the right to bring an enforcement cause of action on you for that. But the bottom line is we're going to communicate through it, not email, not texting. We're going to do everything through AppClose, AppClose. I'm looking at or granting the modification of child support. I'm going to start the modification of child support. That I'm going to go ahead and start the first day of October. I'm sorry. Let's go ahead and start the first day of September 2024. I'm going to order the cash medical and dental go down to 0, but I'm going to order those starting the first day of May 2024 also. So as of the 30th of April, the judgment amounts, and it's only medical support, it's not cash, I'm sorry, it's not dental. So the judgment amount as of the, here we go, 31st, 30.
You might get there before me, Your Honor. But I'm showing, begging your pardon, Your Honor, I'm showing on the child support 13,369.23.
Correct. And the cash medical is
16,247.92, and I got a squint for that. It's pretty small.
Yeah. And so repayment on the child support amount going forward, the interest alone on that amount is $65. So I'll order repayment at how old is this? There's one remaining child or 2 remaining children? I'm sorry.
One, Your Honor, the child's a teenager.
And how old is he, ma'am?
Oh, she's 13.
Excuse me.
Okay, so she's gonna be around a while, so this is gonna take a while to pay off. So I'm gonna go ahead and order repayment on the child support at $100 a month and repayment on the cash medical, which is actually more than the child support that's owed, and an additional $100 a month. So, you know, sir, those are the judgment amounts. And again, I'm not seeing any way to get around those because they became due and owed and subject to a finding of non-payment the very first day of the month after they were due, and those are 100% hers. So it is what it is, sir. Anyway, I'll go ahead and order the like I said, the repayment on both at $100 each, and I'll order those to start the first day of October 2024. I'll waive court costs due to military service. And those are the items I think I got before the court, Mr. Diamond. Is there anything else I need to specifically rule on, sir?
I think no. I think the court's dealt with it, and thank you, Your Honor, for the judgment date. If I could just ask the parties to stick around, the order is mostly drafted. I can hopefully have Matt here in about 10 or 15 minutes. All
right. I'll just remind the folks that the four corners of your divorce decree still controls a great deal of this case, not this order that's coming out. We just modifying certain things. So again, this is an old decree of divorce. You may not know your rights and duties under that. So if both of you might want to go ahead and sir, if there's someone with the VA can go over this and tell you what your rights and duties are, you might want to do it, ma'am. Same if you want to check with someone, go back, or you can even go back to your old attorneys and reconfirm. I know lay people don't get it. It's a 30-page, it's a 25, 30-page document, and it's got a lot of junk in it. But we got a child that's still 13, one child still in who's under 13 years old, and dad has still certain rights, mom has certain rights, and I can't give you legal advice on what those rights are, folks. I can read it and tell you, but I just can't. So the bottom line is you might want to get a refresher on this because you still got another 5 years to go. And sir, there's probably an excellent chance in the next 4 to 5 years, 3 to 4 years, you might be back in, especially if you get 100% disabled, then obviously you're gonna start getting $4,000 a month from the federal government, and that is definitely a material change of circumstance, and that the court will have to take a look at. And I plan on being here for at least the next couple of years, so it may be me, but after that, you're gonna have to deal with somebody else altogether new. So anyway, I'll start with you, ma'am. Any questions, anything else at this time?
No.
All right. Mr. Baker, any questions, sir? Anything else at this time?
No, Your Honor.
All right, folks, I'll go ahead and let the state prepare that order. Please hang around. He's going to send that over to you, but he is going to use email because that's what DocuSign uses. And then, of course, you have the right to ask my district court for a review of this further order. You have the right to ask me for a new trial, but everything's got to be the new trial has to be done within the next 30 days. And y'all can run it by your lawyers to see if I was correct in my evaluation. And if not, then obviously they'll file something to get you back before me and say, hey, Judge, you were wrong about that judgment. But again, this comes up every now and then, unless they've changed the law on me in the last few years, then that's the way it is. So anyway, good luck to both of you. And again, folks, ma'am, go ahead and set up that app close account and be sure to put Dad's in what you have, and then and confirm, since y'all do have email, confirm by email that the app close account is set up, and that's what y'all need to use going forward. All right.
Yes, sir.
All right. Now, again, thank you both very much, and we're off the record.
Thank you.
Thank you, Your Honor.
All right, just a moment. I'll be ready to go on the next one, but I got to finish writing this one up. Thank you.
So do we stick around or are we done?
You need to stick around, sir. Thank you.
Oh, okay. Thank you, Your Honor.
He's going to confirm that y'all got the new got the court order to review by DocuSign. Thank you.
Yes, he's saying join the breakout room now.
All right, go right ahead. Thank you.
Yes, sir. Thank you.